Welcome back and welcome to Business and Immigration Law Updates. This will be presented here by a famous attorney from the DC metro region. His good name is attorney Ramesh Khurana from the Khurana Law Firm. This law firm is situated in the heart of Gaithersburg, Maryland. Attorney Khurana is also internationally acclaimed. We are proud to say that he is a part and parcel of the Capitol Forum. Back to his conversation with the moderator, attorney Kenneth Haber. Attorney Haber is from Boyds, Maryland. This week, attorney Haber questions attorney Khurana on a very crucial topic in the field of immigration. Let's share that with you now.
Welcome. My name's Kenneth Haber. I'm a former assistant United States attorney and a former senior attorney in the Office of Investigations of the Office of Inspector General of the U.S. Department of Health and Human Services. With me today is Ramesh Khurana. Welcome, Ramesh.
Thank you, Ken.
Ramesh is one of the foremost attorneys in immigration law, and this is the Capitol Forum.
I appreciate your nice introduction, Ken.
It's from the heart, Ramesh. You are one of the best immigration attorneys that I know.
Thank you so much. It's always a pleasure to come back on the Capitol Forum.
It's truly my pleasure to have you here.
And especially answering your questions.
Well, I certainly want to make sure that they're piercing and that they're informative for our audience.
I like the word piercing, yes. These questions have to be very piercing.
Yes, everything changes so quickly in immigration.
That's true. Every day, the immigration laws are changing. These are already so much complex, and these are becoming beyond the understanding of ordinary people.
And I'm sure they're getting even more complex with the new administration.
Yeah, because now so many other aspects are being talked about, like ban on travel of people from some countries, and even green card holders. They are coming on the hook as well, in some respects.
Isn't the green card issue sort of problematic because the United States has already issued a green card, presumably, to the green card holders?
But that's right. But, whatever are the government policies, we have to go by that.
Isn't it been historical that the executive branch decides exactly who and how people can come into this country?
Well, that's very true, that this is the executive branch which decides who and what kinds of people can be allowed to come to this country, because every sovereign country has its own right, but at the same time, in a democratic country like our country, there are checks and balances.
Yes.
Like all the three branches of the government, they are equally important, whether it's judiciary, legislative, or the executive branch. So no one branch can work in isolation. So because of checks and balances, the other branch wants to make sure that whatever actions are being taken by the one branch, those can be validated in terms of the Constitution.
And Congress executes the actual, or creates the immigration law that is the framework for the executive branch to operate in. Is that not correct?
That's very true. That's very true. But at the same time, when we come to the interpretation of those laws, then the judicial system comes into the picture.
That's true. And on top of that, the administrative system, the executive branch administrative system, has administrative laws deciding those things as well, don't they?
That's right. Yeah, I agree with you.
It gets very complex, and I understand.
Very complex, yes.
I understand there was a major change January 17th of this year. Is that correct?
That's right. Before the new administration came into business.
3 days.
3 days when President Trump was sworn in.
That's right. And there was a new regulation put out?
Can I tell you, this is something which has been going on since November of 2014, when President Obama had indicated that he wanted to make some improvements in order to hire and retain certain high-skilled workers so that U.S. employers can have the full benefit of these talented people. So this is something which has been going on now almost for 1.5 years, and finally these rules have been issued as from January 17th, 2017. So it just happened that the final rule was issued 3 days before the new administration came into being.
That was very timely because it came out during the subsequent administration, they could have possibly put out and stopped the regulations from actually being implemented because it was on their watch then.
Well, we do not know that because the order was issued on November 20th of 2014, then because of the rule-making process, so that's why it took so much time. Otherwise, these rules would have been made applicable as from November of 2014 itself. So as you are aware, nobody is better aware than you, because that's the way the rule-making process is. It takes some time.
It certainly does.
Yeah,
It certainly
but
does.
anyways, now we have the rules in place, and we have to be guided by these rules, which have been implemented as from January 17th of 2017. And this is mostly in regard to the retention of high-skilled workers by the U.S. employers.
And it has to do with, some of it has to do with revocation and priority date of retention of these high-skilled workers?
That's right.
And how does that factor in?
Yeah, sure. The question which you have asked is, I just want to clarify for the benefit of the audience that we are going to discuss about the new rule regarding immigrant petition, which is I-140 petition, which is filed after the perm application is certified by the U.S. Department of Labor. So within 6 months, you can file the I-140 petition. Now the question is whether the employer is entitled to revoke it. The answer is yes. A employer can revoke I-140 petition, which is already approved by USCIS anytime. Now, even the Department of Homeland Security or USCIS can also revoke the I-140 petition if there was an element of fraud or there was some material mistake, which is the new term which has been added as from January 17th, 2017. So it can definitely be revoked, but if it was due to some fraud, then the benefit is gone. But if it is just revoked by the employer after 6 months of the approval, that's why it's called a 180-day rule, then the employee can continue to have the benefit of this I-140, and they can retain the priority date which is given in terms of the I-140, and secondly, they can continue to extend their H-1B status beyond even 6 years of the term. As we are aware, the maximum term permitted for any H-1B petition is 6 years. That's the ceiling, unless some other processes have been started, and what is the phase of those processes. So if I-140 is approved, then every time an employer files the H-1B petition, it can be extended for 3 years. And this is for an indefinite period of time till the priority date becomes current.
So they can continually file new I-140s.
No, I-140 is filed only once unless it is revoked. Now, if it is revoked after 6 months, you are entitled for the extension of H-1B based on this I-140. You are also entitled to retain the old priority date, but once you change the employer, you have to file a new H-1B petition.
Do you have to leave the country to file the new H-1B?
Again, there are certain situations. If you are in good status, you do not have to leave the country. You do not have to leave the country. So you can file for change of employer. In most of the situations I have seen in my practice when a person is working with one employer and that employee changes his or her mind to move to another employer, then basically that new employer will file an H-1B petition for this employee while this employee continues to work with the existing employer. Once it is approved, then he goes through the process of serving a notice to the employer and joins the new employer. Yeah, that's the way it works.
That's the way it works.
Yeah.
What's the new and improved aspect of this regulation?
Yeah, so it depends which question we are talking. Let us say now there is a 180-day rule. Like I did talk about it in my opening presentation when I was summarizing all these important changes which have been made to retain high-skilled workers by the U.S. employers. So when we say that 180-day rule, if the I-140 petition was approved by USCIS at least 180 days before the employer makes a decision to revoke it, it has no impact on the approved I-140, only in terms of that the employee can move to another employer and apply for another H-1B petition for the period of 3 years. So, this is something new. Otherwise, under the old rule before January 17th, if the employer would revoke I-140, then probably it was in a different kind of situation.
What's the EAD application, and can you explain a little bit about their adjudication?
Yeah, sure. EAD application is basically employment authorization documents. Now, EADs are issued by USCIS in various situations. Let us say a person is going through the process of I-140, and I-140 is approved, and that person's priority date has become current now. When the priority date becomes current, then that person can file for adjustment of status, which is called I-485 stage. When the adjustment of status application is filed, that person becomes entitled for an EAD. So, he can have an EAD along with his H-1B status if he wants to keep H-1B status. We always recommend that you keep your H-1B status even though you have been issued an EAD, just in case something happens and the underlying labor certification is revoked or I-140 is revoked because it turns out that employer committed some fraud, then this person might go immediately out of status. But if the person is keeping his H-1B status alongside, so that means that person will not go out of status, and this person can again restart the perm process with another employer if another employer is willing to do that. But remember, it's all employer driven. Beneficiary himself cannot file any H-1B petition or I-140 petition. These petitions belong to the employer only. So, then EAD is also issued based on H-4 petition. Like if I-140 is approved for a spouse, the other spouse can apply for the EAD based on approved I-140 petition of the employer. So, this is another element of benefit which was given by Obama administration, because the reason was that H-4 spouses in most of the cases, they are highly educated, they are talented, and they get discouraged when they are not allowed to work in this country. So, this is how USCIS felt that in order to involve and fully utilize these talented people who are sitting on H-4 visas, they should be allowed to work. And now these spouses can apply for work authorization.
Very good, very good.
This was a great development. Like quite a few years back, they allowed even L2 visa holders, basically spouses, not children. So, they are also allowed to apply for EADs.
We're starting to run out of time. I just want to ask a quick question, and that is the concept of the 60-day grace period.
I love it. Can I tell you, there was a big problem before 17th January of 2017. If any H-1B beneficiary lost his job, that person technically went out of status very same day. So, there was no mercy unless you asked for the forgiveness, and this forgiveness was granted by USCIS. Now, in terms of the rule, you are given a 60-day grace period. Within 60 days, you can apply for change of status, or you can find another employer. If you find another employer, so you will be considered in status for the purpose of petition being filed by another employer. I love this rule, and this is really very beneficial for the H-1B visa holders.
Is there a 10-day grace rule?
Yes, 10-day grace period rule was already available for H-1B holders. Now it has been extended to other visa holders like L1, E1 and E2, etc. Again, this is before You come in this country so that you can come 10 days before and you can live in this country 10 days after. But remember, this 10-day grace period is just pack up your bag and get ready to leave. And this is not for the purpose of allowing you to change your status.
Well, I'd like to really thank you for coming in. You know, this is a very complex area, and I'm sure you would agree that if anyone has questions, they need to get a hold of a competent immigration attorney just like yourself and
That's
get
the key.
them to answer these
That's
questions.
the key. We always advise our clients that immigration laws are as complex as tax laws. So always get in touch with a knowledgeable and experienced immigration lawyer so that you are put on the right path and your immigration dreams are fully protected.
Thank you very much
Thank
for
you.
coming in.
Thank you. I appreciate it.